Since 2020 to definite an unprecedented scale of economic sanctions and the role that affects arbitration on different kind of layers. There are sanctions regimes against Russia. Of course, they have a significant role in contractual relationships. When we talk about the interaction between arbitration and sanctions, as our panelists will discuss this in more depth, we need to focus only where the sanctions appear in terms of the arbitration. The sanctions show up in the substantive law as a lex contractus, also appear in the terms of the place of arbitration, the role, the place of enforcement is really critical. And of course, it also influences how we set up the arbitral tribunal. There are many sanction-related disputes, but we mean that the sanctions exist under the sanction trigger the disputes. We try to think whether there are something like that typical sanction-related disputes. I also had this question here. Are there any typical sanction-related commercial disputes? In fact, these disputes, what we can observe, and probably this is something that will be discussed in the panel around non-performance. Force measure, how it is interpreted, how we can deal with it, whether the contract itself at the time the contract was formulated, what are the contractual provisions in terms of the sanctions at that time. Relevant EU sanctions in arbitration, we also already discussed the merits aspect. The arbitral seat, the big question here, and I'm sure that we will receive some answers, whether delocalization of the arbitration process, finding a place of arbitration when EU sanctions are not applicable, would release the arbitral tribunal, a big question from the application of the EU sanctions. We also have further questions here, where the arbitral award would be enforced. It's a critical question, and of course what we expect from the arbitrators, the duty of an arbitrator, I know it's, and put it very simple, to render an enforceable award. And how far this duty goes, how far we can expect from an arbitrator to think about the potential places of enforcement, whether it's a task of an arbitrator to think, oh, where are the assets? This is something that's debatable, but still, these are things that we try to elaborate more. In terms of impact on substantive issues, I will talk about this a little bit later, but only briefly. Of course, this is a private international law angle and the lex contractus angle of the program. Impact on procedural rights and procedure itself. This will be the issue of injunctions. That is also a topic that we will address in the panel and also myself briefly. When we were preparing for this panel discussion with the colleagues, we said, oh, we will go in very specific issues and very current issues, but what is the legal nature of the sanctions? What are the sanctions? So we decided that we have a little bit, just as a starting point, that what is the sanction itself, and we talk about what is the UN sanctions and what we consider that EU economic sanctions, rather called restrictive measures. I also have there some forms. I know that I see the audience, of course, is very trivial, and the audience is experts, but this is law, but we need to consider, maybe it's not a policy matter. So when we reach this level, that's when we will address the issue of overriding mandatory principles, public policy. It means we need to take into consideration, even if it's measures, but this is, it's not only policy, this is law. Private international law dimensions, just very briefly. Economic sanctions, it's no dispute over this, and we are not here, of course, to elaborate on this rather academic question. It's an overriding mandatory rules. Yeah, they are part. This is a type of overriding mandatory rules. But the question is rather for an arbitral tribunal perspective, arbitration perspective, what about arbitration proceedings itself? So whether the arbitral tribunal is bound by the Roma regulation. Of course, we know the answer for that, but still why they should consider sanctions. Where sanctions appear, first it can be the arbitrability of the dispute. This is something that's through a case probably will be addressed in the current case, a rebel case, will be addressed by the panelists. Arbitrability, the mere fact. I mean, this was simply, if we try to explain this very simply, the mere fact that an economic sanction is here or part of the dispute, it doesn't mean that arbitral tribunal is denied from the fact to arbitrate the dispute. The Raimanova case is going to be interesting from this perspective, how we are going one step further and the arbitrability will be questioned. The other very important element can be, of course, the applicable law. We have already mentioned this, under the lex contractus aspect. It is also something that is settled already, that if that lex contractus includes the law applicable to the substantive, the applicable law to decide the merits of the case, if it includes overriding mandatory principles, we consider the sanctions as an overriding mandatory principle, then it's part of it. So the arbitral tribunal, we need to consider it. In terms of the lex arbitri, something that probably we can think about, whether the arbitral tribunal needs to pay attention to the sanctions as a place of arbitration, because that is part of the lex arbitri. But we need to think, and arbitral tribunals definitely think about that, is the annulment of the award. So what's going to happen if I don't pay attention to the sanctions, whether it would be an issue, and it would be in terms of the annulment of the award at the place of arbitration. We already discussed the issue of enforcement. The New York Convention, how New York Convention approaches the issue of public policy, of course, it's a different topic, but definitely it has a narrow interpretation. It's more narrow interpretation than we consider domestic or EU public policy. But today we rather focus on EU sanctions and probably EU public policy, and the sanctions are part of, the sanctions considered to be part of EU public policy. So this is also for the arbitral tribunal something to take into consideration when they think about the award and the future of the award, both in terms of annulment and in terms of recognition and enforcement of the award itself. These will be discussed, some of them, in the panel, where we see that there are kind of frictions, legal frictions, of not problems, but kind of competing values. On the one hand, is party autonomy, definitely, that there is a chosen law, a forum, and we also expect enforcement under the New York Convention. And of course, there are some issues that in reality, for years, there wasn't really a problem. Of course, there was a problem. It seems it's very simplistic to formulate like this, but what we see now, definitely, and this is something that will be discussed more elaborately, that EU rules reach more deeply into arbitration, and not only in terms of investment arbitration, but also in terms of, and this is something that in terms of international commercial arbitration. So what we issue as public policy matter, it seems to be more broad. Just if you may allow me, we also have here, and this will be discussed, a very now highly debated and expected and weighted Raimanova case, and so far we have the Advocate General's opinion. And it's, I think what it was said, it's very something that definitely demonstrates the current situation. So the Advocate General beyond it described the relationship between EU law and arbitration as two ships in the night. They barely notice each other in the dark. They keep appropriate distance to avoid collision. They limit their communication to the strictly necessary, and they never cross each other's paths as they sail into opposite directions. Yes, but now we might see, we can see a trend that the ships are on a kind of collision course, and we will see what the future in these terms will bring. The last issue to address before I rather conclude, where we can see this three kind of arena. Rules arena we have already discussed, and of course it will be discussed later in more detail. The courts, this is something for a minute to stop, because the panel will go into more analytical discussion on this. This is a matter of injunctions. So due to the anti-arbitration, anti-suit injunction, anti-suit injunction, this is what we call the obeying counter-injunctions, something that is related to the EU sanctions and the Russian and related disputes. The Lugovoyev, of course, many of us have already heard about it a lot. Just to have this as a starting point, the issue of exclusive jurisdiction that was enacted in the commercial procedural code in Russia, and affecting sanctioned, helping sanctioned affected Russian parties. It means that the parties who has the right actually makes possible for them to walk away from an existing and valid arbitration agreement, relying on this provision. The reason would be, and actually this reason doesn't really need to be proved, it's already implied, that the denial to access of justice. There is a presumption, they don't need to prove that this assumption is actually here, that they don't have fair trial in an arbitration or in front of another national court. But the other provision that can be interesting for us is the next one, and this is the one in connection anti-suit and anti-arbitration injunction to block foreign proceedings, arbitration proceedings, old court proceedings, in the sense of the arbitration procedure already commenced, that one of the parties can receive an order that, well, you need to stop. And stop is not a good term. And I don't want to go, of course, now into details, but how difficult is the situation also in practice for us to interpret this institution, that what it means. Should we terminate arbitration, or if we are expected to discontinue arbitration, suspension would be sufficient? Would we comply with such an order, with a mere suspension, but not termination, not withdrawal of our claim? And how this procedure moves affect the statute of limitation, because from a tactical reason, maybe just makes sense to initiate the process to ensure the statute of limitation issue. Then we have a suspended arbitration. But the question is, not only the statute of limitation is critical, of course, but also what would we need to do to make sure that we avoid or limit the risk associated with the imposition of fines. The fines can be up to the amount in dispute and certain other costs. So whether just suspending would be sufficient, and what we can expect. Just few statistics. Of course, there are more and more injunctions. The Russian courts almost never reject to issue these injunctions. So once they are requested, they will be likely to issue these injunctions and proceed with it, and also to impose the fines. We can see some global trends. We will hear about, as far as I know, about the UK perspective, and we understand the institution more about sanctions. Now I was a little bit going into specific issues. And what is the EU response to this? That we will also touch upon in the panel. As far as I know, this is the regulation we have, the no claims clause. So we can see a certain battle on these three arenas. The big question is that we try to attempt to answer, or on certain level react today in this part of the event, is how sanction rules fit with arbitration's promise. And I said arbitration, but it's important to say with the promise of international commercial arbitration, that finality, neutrality, the arbitral award will be enforced, the New York Convention will be preserved, and enforceability of the arbitral award in general. So this was only my task to a little bit frame the issues and the problem, and the panel will be more far and more deep, I'm sure. And now I pass on to Bálint, right?
Yes.
Thank you, Bálint.
Thank you, Manuela. Excellent expose. That's a great way to start off this panel. And I just want to quickly present everyone from my left towards the very end of the table. We have Miss Lucia Raimanova. She's a co-managing partner at A&O Shearman's Bratislava office. Before relocating to her birth town, she spent over a decade practicing with the firm in London, Hong Kong, and Moscow. She is a solicitor advocate of England and Wales and is well versed in both investment treaty and commercial arbitration proceedings, particularly in the energy sector. She also has experience in litigating in the English, Slovak, and Indian courts, as well as the Court of Justice of the European Union. Lucia is also a board member of the FIAC, not far from here in Vienna, and a member of the ICC Commission on Arbitration and ADR, and she often sits as arbitrator. Thank you for coming. Next to her, we have Marcin Menkes. He is a counsel at Berks Law and a professor at the Warsaw School of Economics. He focuses on international arbitration, both as a counsel and an arbitrator, and also works in sanctions litigation. Next to him, we have Dániel Dózsa. He is a founding partner of international disputes boutique Queritius. He has experience in both investor state and international commercial arbitration under all major arbitral rules, and he regularly sits as an arbitrator. And then next to him, last but not least, we have András László, who is a founding partner at László Fekete Bagaméri, a dispute resolution firm based in Budapest. András is an expert in domestic and international litigation and arbitration proceedings, including commercial and investment arbitration, and he often sits as arbitrator. So thank you everyone for coming, and we have a lot of ground to cover, and just as I get my papers in order, we will explore how the arbitration landscape shifts as a result of sanctions and what this means practically for contract drafting as well. So we will get from that first part to the last part to contract drafting as well. And Marcin, I want to start with you, as you have been looking at sanctions and you have also published extensively on the topic, I would say, before the landscape completely shifted with the most recent measures. The earlier iterations of sanctions packages already began creating massive friction in arbitral proceedings, affecting everything from paying tribunal fees to appointing arbitrators. So could you set the stage for us on how the various sanctions packages disrupted the traditional arbitration framework?
Sure. So first of all, many thanks to you and to organizers, most of all for inviting me, but also for bringing the World Arbitration Update to Budapest. A great event. Very happy to see you here. As we agreed, the idea is I lay the groundwork on the intersection between sanctions packages and international arbitration, and then pass the floor to focus on the most recent 20th package. So the EU's approach to international arbitration is not try to outlaw or get rid of this altogether, but through ever more thick compliance layers make it increasingly difficult. So obviously we started with the practicalities, from access to financial services to travel bans and various measures through which actual participation in the proceedings became ever more difficult. Then we zoom in on international or legal services at large, starting with, and my idea to give you a brief overlook of this, I will be just naming the sanction packages so that you can pin down those elements of the puzzle to the overarching legal framework. So sanction packages 6 and 8 gradually introduce a prohibition on offering consultancy services and then legal services to Russian Federation and Russian entities. Then, after a period of uncertainty, there was a special carve-out for contentious advisory work, yet only the work that is strictly necessary for the contentious matters, which obviously caused a number of questions. So how far can we go? And then also in terms of general offering of or conditions of offering legal services, we have package number 11, which introduced, I would say, surprising carve-out to legal privilege, by virtue of which legal privilege does not free counsels from the mandatory reporting duties with regard to freeze of assets. So if your assets clients could be potentially covered, you need to report your own client to the European authorities. Then going back to what Manuela already introduced, the topic of arbitrage procedure, Article 248, and it's 3 prongs of mostly based on exclusive jurisdiction. The EU tried to push against this in 3 steps. First step was a package from 14th package from June 2024. And first of all, the EU imposed a transaction bans on actors that would take benefit of Article 248 or Article 248 to institute proceedings in Russia in violation of arbitral agreements. And then there are 2 specific grounds for claiming damages that result from awards that refer to the non-performance of contracts affected by EU sanctions. Now, this was relatively narrow, so in December the same year, the 15th package broadens the anti-suit measures. So we see the prohibition on recognition or enforcement of the Russian ASI. And we also, since the Russian courts not only have jurisdiction but can impose huge penalties on actors that would disobey, not comply with their ASIs, I understand Lucia might refer to that with regard to German parties that drop their successful ASIs before English courts. The EU tried to prevent that, withdrawing or refusing to provide judicial assistance to Russian courts that would try to were seeking to impose those penalties. And then this was the state of the art before package 20. That's not my read at this panel, but this was on the eve of functional or effective attempt to create European proxy for anti-suit injunctions. And then since Lucia her work is very much focused on investment arbitration, the particular or specific measures were imposed with regard to ISDS in the 18th package, that is 2025. And here we have the prohibition of recognition or enforcement of any judgments or orders in ISDS proceedings. We have the clawback clause, which allows to claim damages that result from the awards, which basically find EU states guilty of violation of investors' rights as a result of EU sanctions. And on top of that, forum necessitatis, meaning in case EU courts couldn't have exercise jurisdiction based on general rules, then EU member state who's most connected to the case, so usually that will be the defendant state, can, based on this 18th package, exercise jurisdiction. And lastly, that's probably a spin-off of intra-EU disputes about the place of investment arbitration in the EU legal order. States were obligated to raise all possible objections in the case of ISDS. At this point, I will park it because of time constraints. Flag 2 elements briefly from recitals. First of all, the EU calls it explicitly a public concern in the matters of ISDS. The big question is, does it change anything? And the second issue, to somewhat limit ambitions of EU operators, the clawback clause is supposed to be the last resort. So first try to get rid of ISDS, only then try to go for damages. So with that, I think we can move to package 20.
Yes, thank you. Thank you for that great overview, Marcin. And actually, there's a particular case that was also mentioned by Manuela, which is the Raimanova case. And we thought it would be a great idea to get a bit into that. And I would like to kindly ask Dániel to do the 101 on the Raimanova case.
Sure.
Thank you.
So Raimanova considered helicopter parts. So in that way, it was a classic sanctions case. So there was a Belgian supplier and a Russian buyer. And the goods were dual-use goods. So the Russians said they want to buy these parts for civilian use. And the deal with the Belgian supplier, Raimanova, was that the Russian buyer, which Stanko Import, doesn't matter the name, They pay an advance. Then Raible, the Belgian supplier, goes to the Belgian authorities. It asks for an export license. And if the export license is given, then the parts will be supplied. And so in the contract, they specifically excluded EU sanctions as force majeure. So the whole contract, the whole point was that the parties wanted to actually comply with EU sanctions and to the Russians to procure the goods if the Belgian authorities gave their approval. Now, what happened, and you can guess what happened. So the Russians paid the advance. Raible went to the Belgian authorities, who then denied the license because they said that Raible didn't prove to the requisite degree of certainty that these helicopter parts wouldn't be used for the war effort. And then Raible suddenly realized that, well, this whole contractual arrangement is contrary to EU sanctions. So even though it didn't supply the goods, but it wanted to keep the roughly 4 million euros advance that it received from the Russians. And so this is how the dispute came about. Now, interestingly, the Belgian, so arbitration proceedings were instituted. Interestingly, and I don't know what the backstory there is, but the Belgians were represented by a Russian law firm, and they appointed a Russian arbitrator. And the Russian buyer used Belgian lawyers and appointed a Swedish arbitrator. And then the two arbitrators appointed Sophie Nappert, who is a well-known name. So it was an ad hoc tribunal, but surely there was a backstory there, and I think the composition of the tribunal impacted the outcome, as it always does. To recap, so what was the allegation of Raible? It said that Article 11 of the Big Russia regulation, and I don't want to bore you, but it needs to be repeated what it says. It says no claims in connection with any contract, the performance of which has been affected by the regulation shall be satisfied, yada yada, if made by a Russian person. So no claims in connection with any contract, the performance of which has been affected. So the key question was whether sanctioned goods.
Sanctioned goods,
Yeah,
yes. Yeah,
yeah,
okay.
Yeah, exactly. So the goods were sanctioned,
Yes, okay.
or they were dual-use goods, so they were subject to a license. So the question was whether in a scenario where where there's a contract where they want to actually comply with this regulation and an advance is paid subject to the approval, is that a contract which is affected by the regulation, or rather whether the repayment of the advance itself with interest would be in contravention of the regulation. Under Swedish law, because the contract was governed by a Swedish law, and Sweden as the seat of the arbitration. Now, the tribunal concluded that the contract wasn't invalid under Swedish law, nor under the regulation, because the regulation, when it wants to intervene in a commercial relationship, it says so explicitly. So, for example, there's the so-called no Russia clause, where it and I don't know, Marcin, you may know which sanctions package introduced that, but it requires private parties to contractually agree when they sell to a third country certain goods listed in the regulation that they will not be resold to Russian parties. So it's actually a regulation imposed private law obligation. This 12. Okay, so 12. So that kind of provision wasn't included in relation to this clause, and so the tribunal found that the contract was valid, but it could not be performed because of the EU sanctions. I forgot to mention that the claimant in the meantime terminated the contract and so was claiming the advance back. And so the tribunal found in favor of the Russian party to the extent that it reclaimed the advance with interest. It dismissed other damages claims. So that was Reibel. I'm not sure you want me to go to the Advocate General opinion. I can do that quickly, or I can pass back the...
Yeah, please go ahead. Yeah, you should.
Okay, I can do that. So the Russians won in part, and then Reibel went to annulment before the Svea Court of Appeal in Stockholm. And that court made a reference for a preliminary ruling. Now, the problem with that reference is that no party in the arbitration raised the question of arbitrability, whether a dispute related to sanctions is arbitrable, bless you. But the court on its own motion did raise that issue in its reference to the court. So now we have a situation, a kind of, I would say, a pre-Acmea moment, but we may debate that, where the Advocate General eventually did say that sanctions disputes are arbitrable, and now a lot of people are happy with this, but I suspect that the court might defer. So the Advocate General opinion came out not so long ago, and it says that that this provision doesn't prohibit the making of claims. So it only says that the claims, if made, shall not be satisfied. So it means that you can actually bring a claim before a competent forum. It just cannot be satisfied, whatever satisfaction might mean. Now, there are two provisions or two sections or two sayings in that opinion, which I think are very interesting, and they kind of relate to Trenguta's puzzle pieces, I think. One is that in the view of the Advocate General, arbitral bodies are guarantors of that EU law will be applied correctly. And then it also says that arbitrators should deliver an award incapable of being challenged at the seat on public policy grounds. And so if we now think about the evolving role of arbitrators, it seems that, at least according to the Advocate General, now that this role, this other puzzle piece in these interlocking realms, is the role of the arbitrator to actually enforce EU law similar to a national court. There are two other things about the opinion that I think are problematic or warrant caution. One is that in the opinion of the Advocate General, if someone, an EU operator, chooses, so the choosing of an arbitral seat outside the EU could mean that whoever chooses that is exposed to penalties under the sanctions rules, just because it chose a seat. So there's an EU operator, it chooses Singapore or whatever, Hong Kong or Egypt as the seat. That tribunal disregards EU sanctions. The party who just chose that seat could be exposed to penalties. Now, the other is that, and it kind of almost follows from this quite extreme opinion, that the payment of the award so complying with an award that in the EU's view is contrary to EU sanctions can also expose private parties, so not states, private parties to penalties. And that position kind of mirrors, I think, the Commission's decision, the Commission's position in Antin, for example, where it held that even an involuntary payment by a state, so there's an enforcement action against Spain in the US, and if that enforcement action, which is contested by Spain, is successful, that will be, in the Commission's view, attributed to Spain as a voluntary decision of Spain to pay that award. And I think this is the same logic here, that if you choose an external seat, then suffer the consequences, even if you contested the claim and contested the enforcement. So I think that's that's Ribal.
Excellent. There's so many things there, but I just want us to go forward, and it's quite obvious that with these cases, there's more and more instances where national courts, national law gets involved, and then especially in the European Union, then you get to the Court of Justice. But let's step out of the EU a bit and go to the UK, because there's a specific and interesting view from English courts, which have become increasingly assertive, particularly regarding anti-suit injunctions. And I would like to ask Lucia to give us the view from London, and specifically what are the key takeaways and conclusions that practitioners need to draw from the landmark UniCredit case.
Yes, so this may now be a little bit of yesterday's news, but there are actually two UniCredit cases. Might surprise you.
For you.
But one of them is more recent and less well known, so I'll talk about that case a bit more. But first, let's take stock where we are in the UK, because we went full circle within just a couple of years. We didn't have to wait for 20 years. But so as you know, the English courts have the power to grant anti-suit injunctions in support of an arbitration agreement to ensure that those agreements are honored. And there are two main grounds, and I'm simplifying this greatly. One is the contractual one. So if there is a breach of an arbitration agreement, an anti-suit injunction will be granted. And the threshold is not very high for it to be granted. The second one is a non-contractual one. And under this ground, you have to show that the foreign proceedings are otherwise somehow vexatious or oppressive, which is quite a high bar to meet in contrast to the contractual ground. And so following the imposition of EU sanctions, a wave of cases arose from a common pattern. So Russian parties relied on the Lugovoy law that has already been mentioned, and started bringing claims in the Russian courts and bypassed the contractual arbitration clauses, and of course also the sanctions mechanism that was introduced. And a number of these cases concerned Rushem Alliance and various banks who refused to pay under certain bonds due to EU sanctions. And Rushem then commenced proceedings in Russia in breach of the arbitration clause that was in these bonds. And the relevant and the contracts or the bonds were governed by English law, but provided for ICC arbitration in Paris. And the first case was actually brought by Deutsche Bank. At first, it was dismissed by the commercial court. The Court of Appeal then reversed that decision and granted the anti-suit, which was unusual because of the foreign seat, but because you had a seat of arbitration in Paris. But the court ultimately acted because it considered the arbitration agreement was governed by English law. That was before the amendment to the Arbitration Act. And the courts of the seat could not issue the injunction, and evidence was put forward before the court that the French courts would not object to the anti-suit, so that the model law was drafted to that effect. And in the meantime, other banks, amongst them Commerzbank, for whom actually our London team acted, and UniCredit also applied for anti-suits. But as you may know, Rushem struck back. It obtained its own anti-suit injunction prohibiting the banks from initiating or continuing any proceedings outside of Russia, and ordered them to take all measures within their control to cancel the effect of the English anti-suit injunction or pay very hefty fines. And for UniCredit, I think it was around 250 million. So the banks had not much choice because, and the important point here is that the banks, they all naughty, they kept their branches in Russia, right? So that was a big mistake, but of course, greedy bankers couldn't let the subsidiaries go. So they had actually quite a lot of assets in Russia, although they were sort of frozen there because they could not get them out of Russia, but they were there, right? And it's still their subsidiary. So they were in a bit of a pickle. So they couldn't really do anything other than to discharge their anti-suits. And UniCredit's case was heard first in the open court in February of last year, and the Court of Appeal discharged the injunctive elements of its earlier order, but left the jurisdictional findings intact. And there are quite a few actually interesting points. One was that struck me how they sort of went about when they were discussing, whether they should sort of condone Russia's breach of the New York Convention effectively, right? And they relied, actually, they appointed a former colleague of ours, very clever guy, Tom Sebastian, as the advocate to the court, because Rashem couldn't be represented, of course, because they were in breach of the sanctions, right? So, or rather, a breach of the anti-suit. So Tom came up with this argument that actually, by bringing the anti-suit to the cancellation of the anti-suit, UniCredit is waiving its right to arbitrate. So that's how they came around it. So they relied on this waiver argument to say, well, you are waiving your right to arbitrate, so there is no breach of the New York Convention by the Russian courts. So that I found to be quite. Yeah, Tom has been a very clever guy all along. And the other thing that they pointed out is that the court noted that had the UK introduced an equivalent to this Article 11C of Regulation 833/2014, which prohibits the recognition or enforcement within the EU of any of these Russian anti-suits under Article 248, it would have come to a different conclusion. But it had to, but given that, I mean, there was a lot of reasoning behind it, but it discharged the injunction, as I said, in the end. And the practical takeaway from this is that anti-suit is not going to help you if you have assets in Russia. And I should also add that following the amendments to the English Arbitration Act, which now provides that the arbitration agreement is governed by the law of the seat, you will struggle to bring an anti-suit in these circumstances, right? So these cases would have been decided differently. Unless, of course, you can still expressly agree that the arbitration clause is governed by English law. So if you want your anti-suit, then you have to now draft it specifically in. If you go to Paris, then you still have to say, but the clause is governed by English law. And then you can still keep your anti-suit injunction. But before I finish, and I will be very brief on the second question, I just wanted to tell you about the other more recent UniCredit case. That's FH Holding Moscow versus AO UniCredit Bank and UniCredit SPA. And this was a case that involved the Russian subsidiary of UniCredit, first of all, which actually commenced proceedings against the Russian subsidiary of a Cypriot fashion house company with outlets in Russia. And it commenced the proceedings in Russian courts under a mortgage agreement that was governed by Russian law and provided for exclusive jurisdiction of the Moscow courts. And on this occasion, we found ourselves on the receiving end of an anti-suit application from a Russian party who wanted to arbitrate abroad. So they were saying that before AO UniCredit could foreclose under the mortgage agreement, it had to commence arbitration under the facility agreement to determine whether there was an event of default and that there was a breach of the arbitration agreement, they said. And they also argued that by foreclosing, by forcing them to foreclose, there was a risk that they might breach EU sanctions if they have to sell to a sanctioned bidder in the auction. And the facility agreement there was governed by English law. Actually, that it is maybe it was after the Arbitration Act. So I think it's probably the court came to the conclusion that it was governed by Austrian law and provided for arbitration under the VIAG rules cited in Vienna, which is why I got involved in the case to assist with a couple of points that were then not decided. So I was very disappointed. But we prevailed. The commercial court refused to grant the injunction, although then I couldn't do the arbitration, so that was a shame. But at least our client won on that point. So on the contractual basis, the court agreed with us that the mortgage agreement permitted direct access and direct recourse to the Moscow courts. And on the non-contractual argument, the court considered that the risk of there being a breach of sanctions was only very hypothetical, and distinguished the cases from the Rascom, the case from the Rascom line of cases, stating that those decisions addressed attempts to bypass sanctions, whereas this case was premised on a sort of hypothetical future breach, and that was under this vexatious or oppressive ground, where you have to beat quite a high bar. So that was dismissed. The appeal was also dismissed. But for me, the takeaway from this one was there was a bit more at stake, because we frequently advise on transactions that have suite of documents, and you have always the security agreements. They always provide for the local courts, as you will know, right? And often you need quick enforcement rights before even there is an arbitration, right? So I was a bit concerned that if the court wasn't with us on that, we'd have to rethink how we draft this agreement. But the agreement luckily was very, very clear that they didn't have to go to arbitration. They could go straight to the court, and the court could determine the matter. So that's on what I had on that, where we are. So no more anti-suits for people with assets in Russia.
Thank you. That's very interesting dynamics across the channel. So let's move back across the channel to Europe. And András, the European Union's approach has continuously evolved, as Marcin also explained, up until the 20th package. So this culminated recently with the 20th package. So I wanted you to address how does the EU angle look today under this latest package, and how is it shifting the paradigm of European seated arbitrations compared also to what Lucia had explained that goes on in the UK.
Thanks, Bálint. Thanks, and thank you very much for the invitation and for the organization. So the good news is that maybe there are anti-suit injunction, at least those of us still in the EU. As Marcin introduced it, the 20th package completed the European framework relating to sanctions-related litigations and arbitrations. Its stated purpose in its preamble was to stop disputes under Article 248 of the Russian Commercial Procedure Code, and to enable parties to recover damages caused by such procedures. And as it has been already presented, these Russian rules basically provides a right to persons affected by sanctions, or to any person in case of a dispute arising from sanctions, to turn to the Russian courts, who will then have exclusive jurisdiction to decide the case, and also to grant injunctions to prohibit the parties to continue or start disputes elsewhere, including in agreed jurisdiction or in agreed arbitration forums, and also grants the right to the court to impose severe penalties which are payable to the applicant party, so not to the court. They basically function as a type of damages, but they are of course penalties, so they are payable without the examination, the conditions of damages. Now, as again Marcin already introduced, earlier packages, namely the 14th, 15th, and 18th, already introduced certain rules, namely the no claims clause and the transaction ban with entities lodging claims under Articles 248, and also some basic rules relating to recovery of damages caused by claims lodged under Articles 248. The 20th package, which was adopted on the 23rd of April 2026, extended these rules in two directions. First of all, as to damages, it extended the right to recover damages from damages caused by lodging claims, also to damages caused by enforcing decisions in procedures under Article 248. And the other direction is that introduced Article 11C, introduced the possibility to apply for an injunction upholding a jurisdiction or an arbitration clause and entitling the court to grant an injunction to prohibit parties to turn to Russian courts and start proceedings under Article 248. And finally mirrored the penalty system of the Russian regulation, imposing financial penalties payables to the applicant if a party, a Russian party, does not comply with these injunctions. There are a couple of interesting features of these rules, of which I would highlight just a couple. First of all, the extremely wide personal scope catch of these rules on the applicant, on the plaintiff sides, is you have EU entities who suffered damages, but also EU entities whose subsidiaries suffered damages. So that's quite an expansion from traditional civil law, at least on the continent, where you can generally only enforce your own damages. And damages, as well as the penalties in case of the anti-suit injunctions, are recoverable not only from the applicants in the Russian court, but also from their group companies. So parent companies and subsidiaries controlled companies, which is again, especially when we speak about damages, it's a rather bold move, I would say. The penalties, as I mentioned already, they are a very interesting substitute for damages because they have the same functions, but they are of course much more easy to enforce. And then the other interesting issue is the way these rules are phrased. It's that they grant a right to turn to EU member state courts, and they refer to judicial proceedings in EU member state court. So they do not directly touch upon arbitration, which is, of course, because no one has ever agreed to arbitrate this type of claims typically. But theoretically, if there is a wide enough arbitration clause, which extends to claims relating to in connection with the contracts, then these type of damages, so damages caused by bringing procedures under Article 248 in breach of the original arbitration clause, arguably they might even be arbitrable. But these EU rules, on their face and on the basis of their language, they specifically grant a right to recover damages in judicial procedures before member state court, and arbitration tribunals, as we know, are not member state courts. EU parlance. So I think that I'm sure there will be interesting cases to test the limits of these rules, but they're mostly relate to litigations and court procedures in support of arbitration. Yep. I think I'll finish here in consideration of time constraints as well.
We'll be back to you soon. Thank you. And so while the West, as also András had put it, refining its sanctions regime in terms of what can be litigated and arbitrated and whatnot, Russia has in the meantime built some would say, formidable legislative counter strategy. Marcin, I'm coming back to you to discuss a provision that has become notorious in the arbitration community, Article 248 of the Russian Arbitration Procedure Code. How is Russian judicial practice currently applying Article 248 to bypass valid arbitration agreements? And what is the real world impact on foreign claimants?
So when I was thinking about that, asking question where we can end up with the current case law practice, I thought it could be useful to take the baseline scenario or stage before the Lugovoy law, and to highlight that their commercial arbitration and the in international commercial arbitration, Russian arbitrage procedure codes were very much pro-arbitration before the events, and they complied with New York Convention. And even though the mentioned by Manuela Article 248 was enacted in 2020, still in 2022 we have rulings from commercial court from Moscow, which refuses to comply with prosecutors' request to disregard arbitral clause in a claim in an arbitral award between a foreign bank and a Russian state-owned company. So how much more politicized you can get? And here the court still recognized the validity of the award. And until 2022, the case law on the article was relatively scarce, and then it skyrocketed. Now it's certainly above 600. I'm not sure if not above 700 cases in those recent years. And generally, I would agree with what has been said before, that as we see in majority of the cases, because the plaintiff is the actor asking for the ASI as a Russian actor, then as a result, in majority of the cases, the anti-suit injunction will be granted. Here we've started with the landmark case in PESA, later on confirmed twice by Supreme Court. Basically, PESA was a Polish train manufacturer in dispute with a Russian entity, and there basically Supreme Court concluded it is sufficient that actor is listed as a sanctioned entity to state that the EU sanctions constitute an obstacle to access to justice, to full effective use of arbitral proceedings without necessity to prove that actually there was anything wrong. Then we also saw in Lukoy case that even if the actor in question is not sanctioned, the Russian actor is not sanctioned, if the dispute results from EU sanctions legislation, the ASI still may be granted, and that is the prevailing part of case law. However, there are also instances where the Russian courts refuse to grant the ASI. Obviously, where none of the statutory requirements is met, so either unilateral sanctions as a cause of dispute or sanctioned party. But also we have a number of cases where it was a non-Russian, usually European party that tried to use Article 248 to derail arbitral proceedings. We have the case of German claimant, the Aero Central Europe GmbH, the producer of electronic components, who tried to get rid from LCA arbitration with Russian counterpart. We have the Rila, Polish producer of like grain storage facilities, likewise, and there the Russian courts observed that, well, that's not really the reason, because in instances where Russian actors apply for the purposes of LCAA for the grant of general license to be able to pay for arbitration proceedings, that is generally granted. So unless you try, that cannot work as an absolute blockade. So to this extent, we obviously, the most mediatized cases that we find horrific are those where the ASI is granted, yet it doesn't necessarily mean that's always the case. That's one surprise to me. And the second thing which I found interesting was that when we read the statute about the unfriendly jurisdictions, so basically anyone who's using imposing sanctions against Russia, at least my intuition or my first thought would be that the Russian courts would vary in terms of granting or not the ASI would be very strongly driven by the fact where the tribunal is seated in this unfriendly jurisdiction or not. And this again isn't necessarily the case. So we have cases where, just mentioned before, they allowed for arbitration to continue before the LCAI in very unfriendly London, and allowed to derail or have the arbitral proceedings as you just said, in Hong Kong, which is not considered as unfriendly. There were attempts before the Constitutional Court of Russian entities saying that this friendly-unfriendly separation and to strike down the Article 248, finding it unconstitutional because of this distinction. On two cases, the Constitutional Court refused to investigate the matter. In one, they provided some general guidance, which pretty much summarizes what I just said. There are two statutory conditions. They're friendly and unfriendly. If someone is listed, there is a presumption, there are obstacles, difficulties to exercise your rights, but everything need to be tested at CASU. So to close the loop or make the full circle, for me, the baseline was a very pro arbitration. Then the dominating case law is obviously against arbitration. But as we see, referring to what András just said about, for instance, the attempt in the 20th package to impose damages, would you seek to enforce in third parties? So to some extent, to me, this judicial battle is trying to spill over to other states, or we're trying to make it spill over to other states. So how will it go? To me, it's too early to say. That's my guess.
That's great. Thank you, Marcin. And then I think that brings us to an important question of which is that of the seat of arbitration, and if seeing spillovers, or is there still a relevance? Will there still be a relevance to so-called neutral seats of arbitration? Lucia, please talk about that if you would.
Yes, I think, well, my hands will be a bit constrained by whatever the CJEU thinks of this or Advocate General rival's opinion, because it looks like we can only choose EU seat now when any nexus with Europe or something. Well, let's see. But there is no doubt that seat has, in the last few years, I think people have noticed that it's gained in significance. And the 2025 Queen Mary University survey reveals that 30% of respondents have changed their choice of seat in new arbitration agreements, specifically due to geopolitical and economic sanctions. And I have also seen this in my practice, that there's been a notable shift from the traditional European seats, in particular to Hong Kong, Singapore, and the UAE was a big winner, right? And then we are seeing the rise of new centers, like arbitration centers like Astana, where when you have parties who are outside of the EU, arbitrators outside of the EU, then you can sort of have a completely self-contained regime where advocates general's opinions won't matter. But it doesn't always help, as you have heard, because many arbitrators in Asia are also foreign nationals or from UK, so then you have to be careful who you choose. And in Europe, arbitral institutions have been quite good, and also arbitrators in getting licenses. So actually, you can get your disputes arbitrated if you want to. And we have also seen cases. The one in Hong Kong, I think, involved Linde, where Hong Kong was not considered sufficiently neutral by the Russian courts. But I think there were some specificities in that case. But they are quite tolerant of. Actually, Hong Kong is quite a good location, because they're also their arbitral institution is also licensed in Russia, so it sort of ticks a lot of the boxes and hasn't imposed any sanctions, right? They don't comply with any sanctions.
And they just announced the opening of some new arbitration center
In Hong Kong, yeah, maybe.
Maybe that's the reason.
I don't. No, but the one registered is the HKSC. They're registered in Russia. Yeah. Now, has the drafting of arbitration clauses changed? And this is also really a question for you, whether you have seen or clients have been asking about this. Because what I have encountered is obviously parties opting for different seats and quite unusual seats, or they amended their contracts. Sometimes you do it preemptively, right? Where you don't know whether any sanctions will apply or will happen, but you just want to be somewhere different. So maybe the circumvention question doesn't even come there when the sanctions are not yet in place, but there's also no planning for the future, really. I have also seen clauses providing for waterfalls, but they were more for arbitrary institution waterfalls. So if one institution doesn't accept, then you go to the next one, and those are like waterfall institutions. I haven't seen that for arbitral seats because that's obviously more complicated, especially after Advocates General's opinion. But I'm not sure that this sort of circumvention argument applies in all circumstances, because if the applicable law is EU law, sort of one of the EU laws, right? Or if you are an EU operator, then changing the seat won't help you anyway, right? It will still be bound by the sanctions. So if you are just moving the seat to make it easier to arbitrate the dispute, why should that be a sanction sort of circumvention? So I think it requires a much more granular analysis, and it does say may, I think. So it's not like it will always, right? So it will be a very case-by-case basis. It will require some careful analysis, but yes, it will require some brave arbitrators and parties to do that. But I don't think it applies. And also, I'm not just talking now about the EU, because arbitration is happening all around the world. So yes, you may potentially be again in a situation where you can't enforce your award in the EU, but say a Chinese and a Nigerian parties might not care about that, right? And they want to be out of that sort of regime, because we will see Chinese parties getting sanctions, and we are seeing that, right? Especially tech companies. So I think that's the next wave that we will see coming. And I also wonder whether we might see more sort of ad hoc arbitration clauses. So leaving what is, you leave the choice to the arbitrators, so then they probably have to put it in in the EU if it has any European nexus. But yes, you could see more clauses where you just leave the choice either to be agreed closer to the time when the dispute arises, or in case of disagreement, then the arbitrator determines it. We see that, and we have had these sorts of debates where it was like on some of our cases in treaty cases, right? Because you often don't have a seat, but there it was not the party directly affected, but they were sort of, the case had something to do with sanctions, so they wanted to be somewhere neutral where the tribunal isn't looking at, or the courts are not looking at that through that sort of European prism, right? So we might see some more of that. But obviously that sort of introduces a much higher level of uncertainty as to where you made up arbitrating and cause problems when you want to obtain interim measures. So it's not the greatest of ideas, but we live in very uncertain times. And yes, the rival opinion is something to watch out, or case is something to watch out for. As to how what the court might think about that. But I don't know if any of you have, maybe you can tell us afterwards if you have seen any sort of shifts in drafting of the seat clause or arbitration clauses.
Thank you. And so let's say you manage to somehow navigate it and you have an award and you get the enforcement. So how do sanctions affect the enforcement of arbitral awards, also in view of asset freezes and the such? So András, can you tell us a bit about this?
Yeah, well, first of all, of course, you have the arbitral awards, but just to connect back to what we discussed, you also have decisions issued either by Russian courts on the basis of Article 248, that it be decisions deciding disputes, sanction-related dispute on the merits, or imposing penalties, and then on the other side, decisions of EU courts granting damages against the Russian party because the Russian party lodged claims or started enforcement of decisions on the basis of Article 248, or the Russian party failing to comply with the injunction prohibiting it to start or continue proceedings under Article 248 or imposing penalties because of it. And these are going to be court decisions, so it's not going to be arbitral awards, it's going to be court decisions, and obviously they'll be enforceable each within its own bubble, and they're not going to be enforceable in the other bubble. And the big question is the third countries, where you're going to have to look at bilateral treaties on legal assistance and recognition and enforcement of judgment, and I'm not aware of any actual practice. I don't believe there are a lot of practice, especially regarding to of course, relating to the very recent EU rules. Just one comment, whether these are civil cases at all, or to what extent these are civil cases that are, or commercial cases that are generally the subject matter of a bilateral treaty on legal assistance. And then on the other hand, you have what you mentioned, the actual arbitral awards that that decide disputes related to sanctions, maybe in violation of sanctions, and again the enforcement of these awards in third countries, which are might refuse enforcement on the basis of their domestic public policy, but to what extent do EU sanctions form part of domestic public policy of a third country? That's questionable. So again, there are lots of questions and very few answers. Questions also beyond the actual questions of enforceability. What Donny mentioned, what does satisfaction means? If there is a ban on satisfying an award, a claim, does it mean that you cannot apply for and issue a writ of enforcement? Does it mean that the writ of enforcement can be issued, but the bailiff cannot actually enforce, cannot attach properties? Does it mean that in countries maybe luckier than Hungary with a more sophisticated legal system, the bailiff courts can decide to set up an escrow account and transfer monies there from attachment, and then keep it there temporarily and see what happens? Sooner or later, these sanctions are to be withdrawn, and in principle, once the underlying international breaches are terminated. So there's lots of questions, little answers, and just one comment to what Marcin also mentioned regarding to the ISDS related rules of the earlier EU sanction packages. I think that's ACMA again in a different setup. When it comes to exit decisions not reviewable and under public policy on public policy grounds as well, and then the EU law comes in, which as we heard is just another domestic law, and I would not necessarily argue with this position and say that you cannot enforce it, or you have a right to claim damages if it's enforced, which is at the end of the day it's just the same, right? So it's again, we will see how it works out in the practice.
Thank you. Yeah, there are a lot of questions. I would argue that where there's a lot of questions, I think those questions will keep lawyers fed for years then. But then some of the questions that might be answered by lawyers are how do I draft this contract? And this is one of the last questions we'll actually address in this panel. And I would like to ask Dániel to talk about his experience or their experience in what they see and what they recommend be included in these contracts more recently.
Yeah.
Thank you.
So shortly, I don't know. It's a mess. Thank you. But I will tell you a story. So 2 years ago, I went to a conference. I was at Dubai Arbitration Week, and there was a conference called ASAP, organized by which is Anti-Sanctions Arbitration Protocol, organized by the Russian Arbitration Center. It was hidden, so it was on the program, but the room was difficult to find. Honestly, there was a group of us looking for it, and then we arrived late in a full room, and so there was there the vice president for legal for Gazprom. So we went there to listen. Okay, how do you do it? So that was 2 years ago. And 2 years ago, and I summarize now, they said, or he said, you have to agree to ad hoc arbitration because institutions are difficult with handling money.
Oh, cool.
Yeah. But then there was the, unless it's an international organization, such as the PCA in The Hague, and there was this, the Secretary General of the Egyptian Arbitration Center, who essentially made the sales pitch that they are an international organization. So you can agree to Egypt, and Egypt doesn't align with EU sanctions, and it has a great currency, apparently. So there's that. Then he said, of course, choice of seat, Singapore, whatever. But then we have Raibel now. So as an EU lawyer, I'm not sure I would recommend that to clients. Then there's the choice of arbitrator. Of course, outside of the EU, choice of currency. These are kind of no-brainers. Now, at this point, what I would recommend to a client that will likely conclude a contract that might be impacted with sanctions, other than, well, be careful and agree to ad hoc arbitration, I don't know. And I really wouldn't even make an educated guess, because it's a complete mess.
But in the UK, for example, we do, I mean, it's also on the substance, we do draft clauses where we set out all the consequences of, like, when sanctions come, what happens to the contract and all of that. That's quite important. And actually the UK courts, I was quite surprised that quite actually, when they apply these sanctions to contracts, that it's UK is not the EU, and there's sort of growing divergence how these things are looked at. But I was surprised that there are some cases where they just say, well, the contract is not impossible to perform, as you can just switch currency. So they're effectively sort of finding a way to uphold contracts, even when the party is not sanctioned, but they just can't pay. I don't know, because then there is a problem with US sanctions or something. They just say, well, just you can change currency, it's not impossible. So all these sort of things you can provide for, but it depends what the governing law is, how the courts are approaching also the application of sanctions. And so there's actually a lot you can do. But,
you can try.
You can try, but it does help when you know at least, like, okay, if the sanction happens, this is what the sort of rights and remedies are. Obviously, everything will be frozen, and actually you can also have cases where you complete, but because you can get a license to, if I'm suing the sanction party, I can actually get satisfaction, right? If I get a license, and that I have seen that is allowed sometimes. It's just the other way around. You can even have an award, but it can't be enforced, and it's only once, because the sanctions might be lifted at some point when Putin is the greatest friends with Ursula one day or something again, right? So then everything is lifted, and you have you can get your money.
Thank you. We still have some time for questions, but I propose that we close the panel. And we have some discussions in a more comfortable setting where everyone is more free to ask their questions. I want to thank every one of you for coming out and being here with us. And thank you to the support of Sovereign Arbitration Advisors, who sponsored this event and sponsored World Arbitration Update this year. And thank you to José Antonio for making this happen. Thank you to the Hungarian Arbitration Association for promoting the event, as well as the Hungarian Court of Arbitration. And thank you for Mr. President for being here with us. I would want to ask José, but yeah, I would say let's close the panel. This was a great World Arbitration Update. See you guys in the fall at Washington Arbitration Week, and yeah, we'll be in touch. Thank you for taking this, for accepting this challenge. There's more.